Good morning, good afternoon, and good evening. Thank you so much for joining us. I'm Professor Dr. Luis Maria Palma, Vice Chairman of the International Institute for Justice Excellence, IIJE, and immediate Past President of the International Association for Court Administration, IACA. Today, we are developing a webinar jointly organized by IIJE and IACA with the auspices of the Office of Innovation and Judicial Management of the Supreme Court of the City of Buenos Aires, the Attorney General's Office of the Argentine Association of Prosecutors, and the Latin American Association of Prosecutors. The conference is dedicated to judicial security around the world. We bring together worldwide experts to explore how judicial systems are protecting judges, prosecutors, and courthouses in an increasingly complex and volatile global context. We'll examine emerging threats, share groundbreaking how security is not only a necessity, but a pillar of judicial independence and public trust. The topics to be covered by the distinguished speakers who honor us with their participation are: how do countries protect their judges, prosecutors, and courts in a changing world? Emerging threats, groundbreaking policies, how security strengthens judicial independence. I'll briefly describe the rules for the session. The session is being recorded. I'll introduce each speaker before the presentations. Our presentations will be approximately 20 minutes for questions and answers. And we'd appreciate if you could send us your questions using the chat box and identify the speaker to which they are addressed. If you find any technical issues, please kindly use the chat box to inform us. Now we'll start with the presentation of our first speaker, Dr. Guiseppe Fazari, Vice President of IACA for North America. Dr. Fazari, the floor is yours. Thank you.
Thank you, Luis, and good morning, good afternoon, good evening, depending on where you're joining us. It's a pleasure having all of you, and I appreciate Luis' kind and warm introduction, and I'm honored and privileged to share this panel with my with the esteemed jurors joining us this morning. So let me just share my screen here with you. Is that correct? Mentioned our title of our this morning's presentation, and the particular areas that I'm going to focus on for the next few minutes. I'll be very brief because it's only 20 minutes, so we're not really even going to scratch the surface here, but just to kind of give our participants some information with respect to courthouse security. So the subtitle of my presentation is going to be Fortifying the Halls of Justice, some of the considerations that we should have on infrastructure and some of the emerging threats that impact that we have to consider in the court profession in planning court security. So I have basically 4 points of discussion. First, is going to involve the purpose and the function of security. What is the kind of basic function of it? The next is I'm going to talk about some of the basic elements of the security plan, the 5 zones of courthouse security, and then the emerging threats that we have to consider. So this inscription here are taken from the walls of an armory that date back to the 16th century in Venice, Italy. And it really kind of, when I saw this inscription, really kind of takes on special meaning for courts when they're considering infrastructure, when they're thinking about courthouse security, when they're thinking about planning and preparing for security in the courthouse. And it kind of dovetails into this other saying where Seneca, who says, "He who does not prevent a crime when he can," takes on this kind of meaning. It talks about essentially how the courts have to be vigilant and have a plan ready to advance and to maintain the constitutional mandates and the essential functions across a wide range of potential threats that are constantly kind of evolving. And not just potential threats, some of those actions that folks will take on and that are criminal in nature, to the more serious kind of acts that would be, acts of terrorism. And the purpose of court security is to ensure that the safety of all the participants, essentially, in the judicial process, in the judicial procedure, is safeguarded, and to ensure that at the end of the day, the integrity of the entire system is not compromised. When you have security in the courthouse that's conceded, justice essentially cannot be administered. And so court security is not ancillary to those purposes and responsibility, but quite the opposite. It's actually part of the core element, because without that security, without the ability to protect judges, without the ability to ensure the integrity of the process, you basically initiate any kind of purpose or responsibility in that administration of justice. So what is security?
And there seems to be a technical problem with a presentation by Dr. Fazari. I'm going to send him a WhatsApp message. I'm sorry about this. It'll be necessary to proceed accordingly. So with our apologies, we'll wait for Dr. Fazari's re-entrance if possible. In the meantime, we would appreciate to continue. So Dr. Marcelo Quintián, Deputy Attorney General of the City of Buenos Aires, the floor is yours, and we'll wait for Dr. Fazari so he can restart. Thank you.
Muy buenos días a todos. Primero agradecer por esta invitación. Me pone compartiendo un panel con destacados colegas bajo la moderación nada menos que de Luis María Palma. Bajo el roto de la seguridad en el mundo, yo siento que tengo que contarles primero cuál es mi vinculación con esta temática. En eso, luego de fundar la Asociación Argentina de Fiscales en el año 2010, se produce el asesinato de un fiscal federal muy importante, que era Alberto Nisman, el 18 de enero del 2015, que investigaba uno de los hechos terroristas más graves que sufrió Argentina. Fue la voladura, le llaman la voladura de la AMIA. Y este asesinato se produce, el de Nisman, a 4 días de haber denunciado pública y judicialmente al entonces presidente de la Nación y a su canciller por encubrir el atentado terrorista que estaba investigando. Y se produce ese asesinato, además, el día anterior a tener que concurrir al Senado de la Nación para exponer sobre esa denuncia. Al mes del fallecimiento se realiza una marcha en homenaje al fiscal, y ahí, con toda la exacerbación que existía, todos los fiscales se sentían atemorizados, nos vinieron a apoyar distintas asociaciones de fiscales, en este caso las que importan, Paraguay, Chile y Brasil. Se nos ocurrió formar la Federación Latinoamericana de Fiscales. Hoy, actualmente, está integrada por 13 países. Desde ese día, intensificamos nuestros trabajos por la independencia y la seguridad de los fiscales, y en especial, cuando ocurrieron asesinatos, personalmente procuré tomar contacto con las investigaciones, con los colegas de los asesinados, los jefes, familiares de las víctimas. Así, por ejemplo, cuando asesinaron a Marcelo, que fue un asesinato muy conocido acá en la región, fiscal de Paraguay, no solo fui a recibir el cuerpo sin vida en el aeropuerto, sino que tomé contacto con la Procuradora General, la esposa, el hermano, padres, colegas, o como cuando ocurrió en Ecuador, que cada vez que asesinaban a un fiscal, tomé contacto, asesinaron 6 fiscales en un periodo de 2 años, tomé contacto con la Procuradora General, en ese momento Diana Salazar, que acaba de renunciar hace una semana, para ponerme al tanto de cómo habían ocurrido esos hechos. Esta proximidad con la temática me llevó a obtener una serie de datos y elaborar hipótesis que yo llamo contextuales de riesgo. Me explico un poquito más sobre esto porque es el centro de lo que voy a hablar. Supongamos, por ejemplo, el asesinato de un fiscal dedicado a la lucha contra el narcotráfico y que es cometido por sicarios a la salida de la oficina y luego de haber logrado la detención de un capo narco. Rápidamente vamos a decir que los fiscales dedicados a esa actividad específica constituyen un factor de riesgo, pero eso es casi obvio. Pero cuando nosotros tomamos un gran número de casos y evaluamos otras circunstancias de contexto, y es posible trazar características, tenemos la posibilidad de incluir como factores de riesgo esas otras circunstancias de contexto. Yo no sé si ustedes llegan a ver las diapositivas flotantes. Sugiero poner vista del hablante para que se vea un poco más grande. Aquí yo tenía planeado mostrar la actividad de la Corte Interamericana y de la Comisión Interamericana vinculada a las medidas cautelares o provisionales vinculadas a fiscales que sufrieron riesgos. Pero como tengo 10 minutos nada más, voy a pasar solamente por un par de casos. Voy a destacar el primero, que es un caso de fondo, en realidad, de la Corte Interamericana, que es el caso de la masacre de La Rochela versus Colombia, porque aquí se enfatiza la necesidad de una evaluación de riesgos individualizada. Y la Comisión consideró esencial que los estados cuenten con información estadística y un registro sobre ataques e intimidaciones contra los operadores de justicia. El objetivo de esa recopilación de datos es identificar estos patrones que yo vengo diciendo y lograr identificar las fuentes de riesgo para ofrecer medidas de protección idóneas y efectivas. Les aclaro que el registro ese no existe. Bien, gracias. No lo pude encontrar, no están los datos de todos los países. Aún buscando de maneras, si ustedes buscan a través de ChatGPT, Notebook LM, Gemini, todos los atentados que existieron, no van a encontrar la cantidad de casos reales que existieron. El otro que voy a comentar es el ocurrido en la medida cautelar por José Domingo Pérez Gómez respecto de Perú del 2021. Fíjense cómo de un caso, la Corte Interamericana, la Comisión Interamericana, ya empieza a detectar estos indicadores contextuales. Ahí valoró la comisión que este fiscal era integrante del equipo especial Lavallato, que había impulsado investigaciones vinculadas a la corrupción de la empresa Odebrecht y otras constructoras peruanas. Ese mismo equipo de investigadores del fiscal involucra a Keiko Fujimori, que en ese momento era candidata presidencial durante el proceso electoral, y luego de distintos avances en la investigación, el fiscal Pérez logra presentar una acusación en contra por diversos delitos de corrupción y lavado de activos. Además, ese fiscal, considera la comisión, estaba involucrado en 20 casos vinculados con delitos de corrupción en general. El otro elemento contextual que valoró fue que existían campañas en redes donde lo acusaban de ser y apoyar terroristas, o sea, campañas de desprestigio. Esto es grave. Este valor contextual es muy importante cuando se construyen todos los indicadores. Yo estuve con el fiscal Pérez hace 15 días en Perú y fíjense que después de estas medidas cautelares que ocurrieron hace bastante tiempo y parecía estar solucionado el tema, a pesar de haber logrado la condena de los autores vinculados al caso Odebrecht, se le inició al fiscal un proceso sancionatorio y se lo suspendió por 6 meses. Chequemos que se les está traduciendo el inglés perfectamente.
Está activada la traducción ahora, según veo.
Bien. El otro caso que quiero destacar es el de Luis Patricia Benavides Vargas, respecto también de Perú. Lo que quería decir del caso anterior es que pese a que había pasado mucho tiempo desde la concesión de esas medidas cautelares para ordenar la preservación de los intereses y de la seguridad del fiscal, él logra la condena y así todo, la corrupción logra que con el tiempo al fiscal lo sigan persiguiendo y lo terminan sancionando. Obviamente viajamos con la Federación Latinoamericana de Fiscales, hicimos las presentaciones que había que hacer y logramos que finalmente dejaran sin efecto la sanción y la suspensión de 6 meses. El otro caso es Luis Patricio Benavides Vargas. Se investigaba a un presidente en funciones, nada menos. Las investigaciones habían motivado distintos ataques contra la Fiscalía, actos de hostigamiento, campañas públicas de desinformación, descrédito, desprestigio en contra de la fiscal y de la Fiscalía, y buscaban desestabilizar la función de la fiscal general en líneas generales. La comisión valoró eso, valoró las competencias que tenía la fiscal, valoró que había conformado un equipo especial de fiscales contra la corrupción, y además consideró como un motivo especial la circunstancia de que Perú venía siendo monitoreado por la Comisión en relación a las constantes violaciones a los derechos humanos. Esto lo pongo en contexto porque es lo que la Comisión Interamericana viene mencionando, pero yo quiero concentrarme ahora en lo que considero que son unas otras causas que me parece que son necesario incluir. Acá vemos como, verán que yo pongo menciono 4 causas ahí para incluir de contexto y funcionan de esta determinada manera, salvo la primera, que es el caso del narcoterrorismo, que ya solamente la existencia pone en peligro cualquier fiscal. Las otras pueden ocurrir en países donde no hay narcoterrorismo en el sentido que lo voy a explicar, sino formas menores, pero que aún así, si se dan 2 de las otras posibilidades, el riesgo es alto respecto de la seguridad de los fiscales. Cuando hablo de narcoterrorismo, me refiero a la detección de organizaciones criminales en las que no hay que confundirse con simplemente actividades o grupos de vendedores o otros tramos menores, sino auténticos cárteles y sus características. Son esas características las que permiten deducir los peligros y riesgos. Me refiero a los cárteles de México, Colombia, Venezuela, Brasil, donde funcionan cárteles como el de Sinaloa, Jalisco, Nueva Generación, Los Zetas, Noroeste, Juárez, Beltrán, Golfo, disidencias, FARC, Soles, de mucha influencia actualmente, Primero Comando Capital y Bermelo. Para detectar, o lo que es importante de este tipo de grupos para tomar como indicador de estas organizaciones de narcoterrorismo, es fundamentalmente que para ellos la principal característica es el territorio. Para ellos es imprescindible controlarlo de manera absoluta. Esos territorios, sobre esos territorios hay un apoderamiento de funciones del Estado, se lo sustituye y la organización pasa a ser quien provee la seguridad y algunas necesidades básicas. O sea, más típico estilo mafioso. Cuando estamos en presencia de ese tipo de organizaciones, el combate y la judicialización ha respondido de manera violenta, encarnizada y mafiosa. Este es el único indicador, como os digo, que por sí solo determina riesgo inminente, como México, Colombia y Venezuela. Entonces, aclaro que en el 2010 fui a capacitar a Mexicali, a la zona de Tijuana, porque fui a capacitar a los fiscales nuevos porque habían matado a más de 10 fiscales en corto tiempo y se habían quedado sin fiscales. Para que se den cuenta la agresividad y la virulencia de este tipo de hechos. Para los latinoamericanos esto es ampliamente conocido, pero supongo que esta audiencia se compone de muy extensa y no sé si todos están al tanto de estas actividades. El segundo de los parámetros es la violencia institucional. Con esto me refiero, como dicen Daniel Ziblatt y Steven Levitsky, que son 2 politólogos docentes de Harvard, estudiosos de las democracias, dicen que las democracias ya no caen por golpes militares, sino que se convierten en autocracias como formas de ejercer el poder hegemónico por una determinada facción. Ellos advierten que es un fenómeno que viene creciendo en el mundo, pero especialmente en América. A la vista de todos, el sistema es una democracia, pero en rigor de verdad es una autocracia disfrazada de democracia. Hablan del fracaso de los partidos políticos que no saben filtrar líderes y aparecen personajes fuertes que polarizan con la facción rival. Lo convierten en el enemigo y, lo que es fundamental, rompen con los códigos y límites de actuación política, dando paso a la violencia institucional. El sustento de esa construcción es la polarización extrema, la creación de un enemigo y la eliminación de los controles constitucionales y democráticos. Es decir, necesitan sí o sí debilitar y anular la efectividad de la justicia, pero manteniendo la apariencia de una democracia. En ese programa es necesario apoderarse de la justicia, ya sea mediante la sanción de leyes para designar jueces y fiscales partidarios, perseguir a independientes mediante denuncias, descalificar a la justicia en los medios de comunicación para destruir la confianza pública, o sea, todo el manual de la propaganda fascista. Estos ataques tremendos a los fiscales se pueden ver en Argentina en los casos de Luis María Campagnoli, Alberto Nisman y Diego Luciano. Fíjese que se los acusó de todo, hasta cuestiones personales, de estar jugando a la política, o que el determinado proceso, la investigación, era una forma de proscribir a algún político o de perseguir a algún político. Acá en Argentina se lo denomina carpetazo, se lo llegó a investigar y tratar de presionar a través de informaciones de inteligencia, de injurias en las redes. Y esa generación de odio que provoca ese fervor que produce en la sociedad, provoca que algunas organizaciones salieran a la calle a pedir la renuncia de la Corte de manera violenta, por ejemplo, o a un expresidente, Alberto Fernández, hablando sobre el fiscal de la causa y enviándole una amenaza en el horario central por televisión diciendo: Nisman se suicidó. Yo espero que no haga algo así Luciani. Esto provoca una debilidad institucional y es campo fértil para que cualquiera descalifique o empiece a agredir a los magistrados. Y es lo que ocurre. Este tipo de ataques se verifican, esto de la debilidad institucional, de la debilitación, se ve con mucha frecuencia en Argentina, Paraguay, Perú. Pero llamativamente, y esto por suerte acá hay miembros de Estados Unidos, a mí me llegó un informe de que las amenazas graves a los jueces federales de Estados Unidos se duplicaron en los últimos años a partir de la aparición de un candidato presidencial en el escenario político y más concretamente desde la irrupción de los seguidores de ese líder en el Capitolio, como parte de una creciente ola de violencia política. Esto es un dato del Servicio de Alguaciles de Estados Unidos, no es mío. Las amenazas graves contra los jueces federales a partir de esa violencia política aumentaron de 224 en el año 2021 a 457 en el 2023. Las amenazas contra fiscales federales se duplicaron de 68 en 2021 a 155 en 2023, según muestran las estadísticas. Lo que sostienen es que en el pasado los jueces se enfrentaban a amenazas de personas que estaban molestas por la decisión de un juez, en su propio caso. Pero ahora muchos más esos ataques vienen o provienen de personas que están enfurecidas por la política. Es decir, hasta un país con la fortaleza institucional de Estados Unidos parece advertir este servicio desde el Marshal's Office que la violencia política genera mayor agresividad hacia los fiscales. El otro indicador es la corrupción estructural. Este es un fuerte indicador de riesgo, y acá me refiero dentro de las clasificaciones tradicionales de corrupción, o sea, la individual, la sistémica, la estructural, la legal, la institucional. Yo me refiero a una forma en particular que es la de apoderamiento del Estado, que esta última implica comprendiendo en la práctica a todas las demás. Implica una penetración de la corrupción en todo el Estado y tiene capacidad para obtener leyes y también para regular o dictar cualquier acto administrativo. Este indicador de la corrupción estructural puede hacerse más palpable cuando se mira lo que pasa en Ecuador de hace muchos años. En la diapositiva que se está mostrando, muestra la cantidad de fiscales que fueron asesinados entre el 2022 y 2024. Todos estos hechos fueron de manera violenta. Muchos de ellos, la mayoría tienen la misma mecánica, mediante vehículos, esperando la salida de la oficina o de la casa de los fiscales, con pluralidad de intervinientes y haciendo una cantidad de disparos que son impresionantes. Justamente creo que la charla del primer orador venía por ese sentido de cómo protegerlos, y acá, bueno, no ocurrió. Me parece interesante ver el caso del fiscal Suárez dentro de todos esos, para tomar cuáles son los indicadores que nos entrega la corrupción. Él investigaba hechos de corrupción, vínculos con narcos, y los vínculos con narcos y el sistema judicial. A él lo siguen cuando salió de la oficina, le efectuaron más de 10 disparos a muy corta distancia. Fíjense que ahí está en la imagen de la ventana. Esa investigación del asesinato del fiscal llega en un momento dado a producir un allanamiento en la que dan una enorme cantidad de armas y explosivos. Ahí está la foto del local que se allana. El autor se vinculaba con el grupo Chon Killers, que a su vez este grupo, junto a otros, integraba el cártel Nueva Generación de México. Este grupo, en Ecuador, facilitaba operaciones transnacionales logísticas de acopio, seguridad y salida de la droga. Ese grupo era, fíjense cómo se vincula la corrupción, ese grupo era financiado por una persona que era Leandro Norero, y a su vez, Norero se vinculaba con el expresidente Correa. Ahí se ve cómo la corrupción es fuente directa de riesgos contra la seguridad de los fiscales, porque donde se tira el hilo, se llega a veces a estructuras muy altas en el poder. Y la cuarta de los indicadores, que yo llamo la ecuación riesgo-beneficios, cuando los atentados contra jueces y fiscales no son esclarecidos y juzgados sus responsables, la ecuación riesgos-beneficios inclinan desfavorablemente las cosas. Cuando asesinar, amenazar o presionar a un magistrado no tiene consecuencias, se convierte en moneda corriente. Como corolario, yo creo que es imprescindible la creación de un registro internacional de atentados, como lo sugiere la Comisión Interamericana de Derechos Humanos en la masacre de La Rochelle versus Colombia. Y en segundo lugar, monitorear constantemente estos 4 indicadores que son generales y de contexto, por donde se reúnen 2 de estos indicadores, los riesgos son altos. A estos indicadores obviamente se tienen que sumar las investigaciones particulares de cada fiscal, las condiciones edilicias, existencia de protocolos, capacitaciones en seguridad, etc. Yo no sé cómo ando de tiempo, pero si no les cuento profundamente casos como el de Pechi, cómo lo asesinan en otro país al otro día de haberse casado, o cómo se vinculaban las distintas organizaciones criminales para matar al fiscal. Pero si hay tiempo, yo ya cumplí con los 10 minutos, así que les cuento, por ejemplo, lo que ocurre en el caso de Pechi. Marcelo Pechi era un fiscal que investigaba, un fiscal paraguayo, que tenía una unidad de delitos complejos y se encontraba, investigaba las conexiones narco en la zona de la triple frontera de Paraguay, Argentina, Brasil, y además los casos más relevantes de corrupción del país. Se podía decir que era el fiscal más importante y era de extrema confianza de la entonces Procuradora General, Sandra Quiñones. Este fiscal se casa y se va de vacaciones a Colombia. Estando en Colombia, aparece una moto de agua con 2 sujetos en la playa, se dirigen directamente hacia él, lo le efectúan disparos, lo matan y se van de la misma manera en que vinieron. Hoy se dice, hay dos hipótesis fuertes, una que estos sujetos ya tenían planeado el asesinato, pero descubrieron que estaba justamente en esa playa debido a una foto que sube la chica en su luna de miel, diciendo justamente ahora somos tres, porque se había noticiado de que había quedado embarazada. Que ahí descubren el lugar en el que estaba y por eso se dirigen hacia él. La otra hipótesis es que ya lo tenían el dato desde Paraguay, de que se iban a ir a Colombia, aunque no sabían exactamente a dónde, ya tenían el dato desde antes. Pero lo tremendo es que la investigación, que se inicia muy rápidamente en Colombia, ya tiene a 7 personas condenadas, que son justamente la persona que llevó el dinero, la que pagó al organizador, al contratista, y todas las personas que intervinieron suministrando las armas y ejecutando el hecho. Son 7 personas. Pero lo que todavía no se logró acreditar es quién hizo el encargue y quién encargó la muerte. Y pese a que muchos de los autores ya confesaron el hecho, no se animan a quebrarse, ni a decirlo, ni aún a beneficio que se le ha ofrecido, por supuesto, de alguna especie de acuerdo para beneficiarse con la pena si esclarecen el hecho. No se pudo determinar todavía quién encargó el homicidio de Marcelo Pecci. Entonces ahí tenemos entre los indicadores el contexto de alta corrupción, el tipo de investigaciones peligrosas que se tenían. Esto demuestra que por lo menos nadie pagó por este hecho. O sea, en Paraguay se mandó a matar a un fiscal a otro país y nadie ha respondido en Paraguay por ese episodio. Y el contexto de vinculación transnacional que tienen las organizaciones narcocriminales. Se probó que algunos pertenecían, o algunos de ellos tenían contactos narcos con Venezuela, y otros eran de ahí mismo de Colombia. Bueno, este era el caso más relevante de los últimos tiempos por la forma y por cómo se produjo. Que hoy en Paraguay todos los fiscales están completamente atemorizados. O sea, ¿quién puede salir a investigar después de semejante atrocidad? ¿Se solucionó el tema de los subtítulos?
Sí, Marcelo, ahora sí, fue al interrumpirse el flujo de información cambia el idioma y ahora pueden verlo correctamente. Muchas gracias.
Genial. Bueno, yo estoy, ¿eh?
Excelente.
Muchísimas gracias a todos.
Thank you so much, Dr. Varona Quintián, for your thorough description of cases of threats and attacks of judges and prosecutors in Latin American countries, their root causes and risk analysis, from all of which you've extracted very useful common patterns and presented related indicators. Now we'll go back to Dr. Fazari, who generously continued with his presentation after this abrupt and unexpected interruption. Thank you, and I apologize, Dr. Fazari, for the technical inconvenience. The floor is yours.
Yes, no problem. Thank you so much. Thank you so much. Let me just get back to my screen here. Okay, so where I left off essentially was what is court security? Essentially, and I mentioned how court security, when we think of protecting the courthouse, protecting the staff, particularly the judges, attorneys, witnesses, victims, all those stakeholders who come to use the this form of dispute resolution, this form of seeking out justice. It's not ancillary to the purposes and responsibilities of the court, but quite the contrary. It's actually central and core to accomplishing those purposes. And so maintenance of court security, when you consider it, it is a fundamental requirement of fair and efficient, to ensure a fair and efficient administration of justice. And so to the extent that it interrupts judicial proceedings, to the extent that there are threats, to the extent there are criminal actions that are taken, it denies the rights of litigants to seek out that justice. It denies their right to seek redress and that fair trial. And so, and in very similar fashion, along the same vein, threats to judges, threats to court personnel, threats to attorneys, it inhibits the fair and impartial action that the public comes to rely on the judiciary to carry out. And in so doing that, by virtue of that, it undermines the public's confidence and ultimately, unfortunately, the respect that it will have for the third branch of government. And so, having said all that, court security, the court system vis-a-vis securing judges, securing staff, attorneys, victims, witnesses, all those key stakeholders that come to the courthouse, really have to be considered basically integral. And so when you think of court security, essentially you're looking at it as an integrated system of these policies, procedures, not just what is typically kind of seen as the physical safeguards when you're coming into the courthouse. And through all that, obviously, it's a niche area of the criminal justice system. So you're going to have trained security personnel, obviously, to ensure the safety of judges, to ensure the safety of personnel, members of a public who are coming in and out of the courtroom proceedings. And so, and then obviously central to all that is the leadership, the support of those senior judicial officials, and a sense of ownership by the judiciary of that security process by those court personnel. So it's a feeling, as I mentioned here, it is not looked at in these sort of separate pools, but instead it's a feeling of that safety that folks have, and together with a combined effect that you're able to achieve what you're looking to achieve by ensuring that you're going to detect and arrest those individuals to the extent that they're trying to create a danger for the court. So probably in my experience and in my study of this and in my consultation when it comes to court security, probably I would say the biggest threat to court security is a complacency, right? So the single biggest boost, therefore, that all of us could have in the courts is a sense of awareness. Government employees, when you look at public versus private sector, the government employees, the industries that have the highest incident rates of workplace assaults, workplace security breaches, are public sector. They're 3 times more likely than private sector employees to be victimized of some level, some kind of workplace violence. And in large part, that has to deal with because of, we're dealing with the public. We're dealing with a very large, eclectic, diverse group of folks, many of whom are coming to the courts, during, some of the worst chapters of their life. Very rarely are folks coming to the court in a happy state of mind. I would say the only exception to that is if they're coming to the court for adoption day. Outside of that, even if they're coming as a juror, they're coming as a victim, they're coming as a witness, they're coming certainly as a defendant. Most of the folks are coming in through our doors during a crisis, and there's a lot. The emotional state of mind is very high, and so the vast majority of incidents, when you think about it, are not planned. Actually, they're unpremeditated emotional outbursts that occur in the courts, and not just the criminal courts. Over the extent of my experience, more incidents on these unpremeditated emotional outbursts happen in the family courts, more so than the criminal court. So it could happen in any court system. It could happen in a civil, it could happen in criminal, it could happen in family. And so when you're thinking of court security, and when you're thinking of this idea of safeguarding the institution, the biggest boost is a sense of awareness. And so a security plan essentially is going to have 3 elements within 3 elements, right? So there's a general security of the facility, and it has 2 purposes. It provides you with a general guide for staff and the policymakers. And it also, secondly, serves as a very important operational manual for security personnel. And so it basically spells out for those key personnel, for those key judges and leadership, the executive component in the court, how to address specific issues. And now it need not be massive. The security plan does not have to be some lengthy sort of tome. It could be in most instances, it could be, very sort of concise kind of manual that advises staff, that advises judges how to prevent security incidents and what to do, importantly, if such a thing should happen. You could have a separate second volume that incorporates the policies and procedures, all these different appendices that provide more of a sort of a myriad of the details for some key scenarios. And it does 3 things, basically. It gives you a handle on the general security of the facility. It secondly provides you with procedures of how to handle continuing kind of security concerns, such as, prisoner transport, the theft of documents, theft of personal items, minor kind of medical emergencies, how to handle those kinds of things that can interrupt the judicial process. And thirdly, it also serves as a contingency plan for some of those major security concerns that could come up from time to time and are less frequent. So, for instance, you have a hostage situation, or you have a bomb threat, or you have some kind of protest or massive demonstration, and a more critical, major kind of medical kind of circumstance, a fire, or some sort of biohazard that's been released in the facility, those kinds of things. Now, within each of those 3 elements, and this is where I'm going to go into the 5 zones, within those 3 elements, there are 3 areas of consideration: the architecture of the facility, the operations, and the technology piece. And these are broken up into 5 zones. And so the 5 zones the first zone relates to the facility perimeter. So for the purposes of keeping this as brief as possible, I've kind of joined the operational technological consideration, just to kind of give participants a sense of what we're talking about here as it relates to each of these 5 zones. So the first zone, the facility perimeter, the architectural considerations that you're going to look at are such things as lighting, fencing, parking, landscaping, those types of things. Parking in particular, at the very, very minimum, when you're looking at parking in the facility perimeter, this zone 1 of securing the judges, personnel, and the courthouse, at the very minimum, you should have separate parking that's provided for judges. You should have separate parking for court staff and jurors. That's separate and apart from the general public. You should, in those restricted parking areas, you should have staff that are able to access that space. They should be able to access it via card. Prisoner transportation, such as bringing folks in and out of the courthouse, should be done done through a sally port and also separated from those public parking areas. Obviously, all these parking areas, it goes without saying, they should be well lit. They should be monitored with the latest security surveillance kind of cameras. There under no circumstance should you have any parking that's reserved for judges or restricted to judges. It should never be designated with a sign that says, for judge so-and-so, or for judge, generally speaking. You don't want to sort of highlight where judges are going to be parking their vehicles in any kind of parking space. The other major kind of thing would refer to like landscaping. So any kind of landscaping that's around this zone 1 perimeter should be done and maintained so it promotes visibility. It should be planned and maintained with a line of sight to bolster general safety. If you have a landscape architect and they're looking to put different types of vegetation, shrubs, they should be trimmed low. So it doesn't kind of hinder, you know, what they refer to in law enforcement is this kind of like line of sight to and from the building. So all of that shrubbery, all those kind of trees should be done with that in mind, you know, and elevated from the ground, so that it doesn't hinder that, it doesn't hinder any of that. Okay, so zone 2, so we start off, so if you think of it, if you can visualize it in your mind's eye, like these concentric kind of circles, zone 1 is sort of the outer perimeter. And as you get closer and closer to then the individual. So the zone 2 would be the facility exterior. So this kind of refers to the immediate exterior of the courthouse, the entrances, the windows, the walls, the fire escapes, and other openings. So other openings would be in reference to like manholes or sewers or skylights, air conditioning vents, those types of things. And so these are all the architectural considerations that you would want to look at when you're thinking about security. What type of material those entrances and those exterior components are made out of. You know, what are the location of those types of things, how accessible they are. Walls in particular become more of an issue when you have a courthouse that is a multi-use building. So where those walls are adjoining other facilities that may be part of the private sector, or maybe a part of the county or another government sort of facility. So those walls have to be considered in terms of you know, the safety and security of such things. And how anybody could physically access the building should be part of the architectural consideration. So I've mentioned some of the main sort of components, main types of accessible points of entry that you'd want to take a look at. The operational technological considerations, part and parcel, and it goes also back to that zone 1 as well. So you'll see some of this kind of overlap as well. So you're going to want to have trained staff to monitor those cameras. You're going to want to have the right security, screening equipment. Those are all sort of critical when you're considering safety and security of the judges and the courthouse. You want to try to have the state of the art to the extent that the budget allows, technology, so you could have this sort of maximum impact on security. Considering all the intrusion alarms, you know, our doors, windows, for instance, and other points of access that I mentioned, are they alarmed? Should they be alarmed? How will they be alarmed? Are they alarmed through motion detectors? How will intrusion of those restricted entrances, points of entry, going to be restricted? You know, what's the process? What's the response? What are the reporting requirements? All that. These are all important types of things. Even something as sort of straightforward as, say, you know, entry screening. You know, you have to consider the equipment that courthouse security is using. You know, what sort of problems, you know, certainly will happen if you don't have the right staff there, if they're not trained properly, if they're not provided with the proper procedure. So, you know, these are questions that the leadership has to consider in their security planning, right? So who should be screened, for instance? What do they do if they screen folks and they in fact find a knife or a weapon? What do they do if a person is coming, you know, coming through the entrance point and decides that they don't want to be screened anymore and turn around and leave? You know, are they trying to hide something? What is the protocol for such a thing? What procedures should those screening personnel do? And so you want to establish procedures and protocols that are consistently followed, so you don't avoid some of the common problems that you have and some of the pitfalls that are associated with this kind of entry screening. For years, when I was the chief of operations in Essex County, we have these entrance points that people would come in, and periodically what the sheriff's officers used to do is they used to go around the perimeter of this zone 1 and zone 2 of this exterior. And what they do, they'd go into all the landscaping, and what they would find is they'd find all sorts of different types of weapons. They'd find little handguns, they'd find knives. What folks would do is, as they were coming into the courthouse, they'd hide them in different parts of outside the courthouse because they knew they were being screened, only then to come out later, grab their belonging, grab that weapon, and then leave. You know, so what's the process, for instance? What's the procedure for security to do that? Another key part that I want to mention is this aspect of access control when it comes to the exterior of the courthouse. So there's 3 essential access control points. There's the traditional key control, sort of the hard sort of key that you come in and out. The second is the electronic access control card, similar to what you have when you're going in and out of that restricted parking. Obviously, the main advantage when you have an electronic card access central system that controls access is that you have the ability to change that those programs in the system very quickly to meet new security, new restrictions. You could disconnect those cards if the person or the judge loses or the card is stolen. So you don't have to sort of rekey, quote unquote, the entire system like you would in a traditional key control system. The last type of option on access control would be, some of the more technologically advanced kind of access control related to biometric devices, like fingerprint readers, for instance, or retina scanners. You're really kind of, hand geometry is another type of access control when it relates to biometric. So these are all different types of systems and access that obviously have to match the resources and the budget that the court has, together with, what sort of device, what sort of access does the court want to use as it plans its courthouse security policies, protocols, and procedures. Okay, so zone 3 relates to the public. Now you're moving from the zone 1 to zone 2, right outside the courthouse. Is zone 3 are those public access areas. So every person, every member of the public coming in has the ability to access. So first and foremost would be the courtroom as a public area. So one of the rules in the courts that I've consulted with, one of the rules that I had when we were overseeing various courts here in New Jersey is the rule is no seat, no access. So as a public space, if it's a high profile kind of trial and lots of folks are coming to the courthouse to sit in on that court, it's obviously open to the public. However, you have to sort of straddle the line of, it's open to the public, but at what point does it become full to capacity that it becomes a breach in security, right? So once those seats are occupied, then you're permitted at that point to bar access into that physical space. The courts could do different types of things depending on, again, resources, budget, spacing, or a couple of high-profile trials that we would then record the trial to a different courtroom, and we'd kind of move some overflow folks to courtrooms where, let's say, a judge was on vacation or was not utilizing that space for that particular day, or we'd use it to a conference room with some seating to deal with any kind of overflow of the public that wanted to sit in and view that trial. Together with that, you want to sort of make sure that you have barriers, gates, walls, etc., those types of things that separate the judge and staff and attorney space from the members of the public. And likewise, those areas in each courtroom, particularly behind the judge's bench, should be equipped with the duress alarm. And so when the courtroom is not being used, it should be locked. It should always be well lit. Another key consideration would be for again, tying it with the resources that the court has that is available to the court, is ensuring that the bench is armored in some way. So even if you have that entry screening in place, there's different ways that, folks can get different weapons into the courtroom. And so that would be sort of key, is to ensure that you have some type of bench armor, that it's discreet, that it's effective, it protects the judge, it has that sort of ballistic shielding. And to the extent that the resources are available, I would always recommend extending some of that armor protection to selected staff areas, particularly those staff areas that deal with any kind of cash, sort of key personnel, key leaders in that court, and then chambers as well, right? The public access areas should be equipped so you limit congestion. The hallways, if to the extent that you can, you're developing the space, the hallway should be wide. The visibility should be maximized, so the hallway should always be clean and clear, and again, obviously monitored and with surveillance cameras. Restrooms should be periodically checked. mirrors and cameras should be used to increase, observation and the like. When it comes to those, last point is when it comes to those high-profile trials, the court should be, doing some planning specific for those high-profile trials, right? They're not a surprise. They don't sort of just drop into the court. So there is some lead time leading to those high-profile trials. So the court should do some planning and consider all the points that I'm making here with respect to security. Again, not as an ancillary item, really sort of central and core to the purposes and responsibilities of the court that functions under the operations module, if you will, of court administration. So they should determine, among other things, the specific searches that are going to be done under those special type of circumstances, specifying the who, the where, the what, the how, all that sort of policy and process should be a part of the conversation. Okay, so moving closer to zone 4, which is now the restricted access area. So in the courtroom, in the courthouse, excuse me, where you're trying to limit penetration, right? It's not accessible at this point to the public stakeholder. So those, you want to limit penetration, so you want to close off the hallways that are not public. They should be closed off, and the penetration should be limited by secure doors, automatic closing devices, very good signage so people don't sort of get lost and claim that they didn't know that they weren't supposed to be in this particular space. Particularly any kind of access to the judge's chamber should be controlled using electronic locks, again, with camera systems installed. And those other areas that should be especially protected, any area of the courthouse that houses records, any area of the courthouse that deals in cash, has a safe, computers with restricted access, all of those areas should be, relate to this zone 4. Emergency lights should be present in all those hallways, those courts, those offices, in case anyone, really those sophisticated kind of attacks in the courthouse where they cut off the circuit and then try to limit the movement of those judges and those staff. The rest alarm considerations, right? Where should they place? Does this particular area require it? When a duress alarm is hit, what is the process? What is the procedure in terms of who responds, how they respond, so on and so forth, and all those types of issues. And then along this, I mentioned some general surveillance consideration is obviously some of the questions related to the placement of monitoring stations, the selection of who those folks are going to be designated in terms of monitoring that staff, the type of camera and the equipment that is selected, and the 3 points related to that would be the capability of that equipment, the flexibility of that equipment, and the capacity of that equipment, right? All sort of key sort of points. Other kind of space planning and architectural guidelines, if you had your wish list, for instance, and you were building a courthouse from scratch, these are some of the key points, key components, I would ordinarily kind of recommend as a sort of general baseline, right? Private corridors, stairs, elevators for each category of the persons that I mentioned before: judges, staff, victims, prisoners, attorneys, so on and so forth. Judges should have separate access to their courts. The staff, jurors, witnesses, all separate access. Access should be controlled as it relates vis-a-vis this zone 4. And as it relates specifically to criminal transport and relating to the criminal courts, there should be detention floors, areas in the criminal that are connected directly to the facility that is detaining those incarcerated defendants, that feed directly and only to the spaces where the prisoners are going to routinely and regularly be sent. The detention spaces then should be, so you should have like a holding facility that feeds in from that detention facility that then goes up by elevator or by stairs or what have you, directly to another holding sort of temporary facility that's connected to each of those criminal courtrooms. Again, if you had your wish list and you were building a courthouse from scratch, these are some of the basic kind of general guidelines. And of course, have this video conference that needs to be sort of well thought out for some of that high profile, some of those high profile cases that I mentioned, that I mentioned earlier, and the seating for the public. Okay, so the last zone relates to cybersecurity, and this basically, the courts in this respect, they're no different than any kind of private sector industry or public sector industry. They're susceptible to cyber attacks that expose very sensitive case information that they collect on a routine, regular basis. Personal data that relates to judges, court personnel, court executives, attorneys. This all could potentially disrupt the judicial process. And again, going back to how I prefaced my conversation and discussion here, is if you disrupt that process, you basically mitigate, if not vitiate, all public confidence, right, in the courts. And then it basically curtails anything the court can do. You lose confidence, you lose respect in the worst case kind of scenario. So some of these points that you have to protect and have to consider as you're thinking about court security is not just that hard infrastructure space that you're trying to protect the individuals and the physical structure of the courthouse, is also this cyber world, right? Ransomware, phishing, those types of things, those attacks that could potentially really kind of cripple the court system, that lead to that potential data breaches and operational disruptions. Okay, so some of the last points I want to mention, some of the emerging threats, and they basically fall into two categories: the physical threat as well as the virtual threat. So the physical threat basically are those direct attacks. Judges, their respective families are targeted with physical assaults. And this ranges anything from the most severe and serious of shootings to other forms of violence that relate to intimidation, right? Bomb threats, what's referred to as sometimes what's called swatting incidents. This is where an individual will falsely contact law enforcement and dispatch law enforcement to a judge's residence. And it kind of seems innocuous, but basically it's there to intimidate the judge so that, the judge realizes, oh, this person knows my address. The more recent types of things is where they deliver pizza, or they deliver Chinese food, or deliver some sort of food to the judge's residence, signaling to that judge that, hey, I know your address. So it's a physical threat in the sense that it's indirectly telling the judge and harassing and intimidating the judge that, hey, listen, we're targeting you and your family member, right, with these kind of intimidation tactics. So these are the types of points that relate to some of the more emerging threats relating to the physical, direct, indirect attacks on judges. The virtual threats relate to the online threats, the online harassment. One example would be what's referred to as doxing. This is where they are able, through some cybersecurity kind of breaching of security, or if to the extent that the information is publicly available, they take that personal information of the judge, like their home address, like the names of their family members, these private residents, what kind of car they drive, with their license plates, those types of things, and they put it on the dark web, or they put it on the web on some website, and it makes the judge obviously vulnerable to what then turns from a virtual threat into a more direct physical threat. Online abuse, online threats, social media platforms, which are ubiquitous, right, are increasingly used to spread violent rhetoric, threats to the judges, calls for the impeachment of judges. And it's becoming worse now. That's fueled with political polarization. And so that misinformation, disinformation that individuals use to threaten and otherwise intimidate judges. So those are some of the points of reference when it relates to the emerging threats. So what can individual security measures that judges, court personnel, what can they do? Basically, I broke them down into basically 4 areas of consideration: pedestrian safety, automobile safety, residential safety, and going all the way back to how I started in terms of this sense of awareness, right? And that Ziggy cartoon is this general vigilance, right? So judges, court staff, any individual who works in the government sector, where they could be prone to these kind of attacks, direct or indirect, physical or virtual, is to practice vigilance, right? To be observant what's happening around you. Maintain distance if a person may confront you. Consider the kind of weapons that have been utilized. and, be aware of such things. Keep your distance between yourself and the doorways and, alley entrances where, people can get ambushed and weapons can be concealed. When it comes to automobile safety, some basic types of things, make sure that, as you're, always lock your car, obviously, make sure you always have a full tank of gas, or at least half full. Make sure that, you're checking your vehicle as you're coming to and from it. This is an important point that sometimes goes unheeded, but you should vary the routes that you take to and from your residence to the courthouse. Stay alert. Make sure that you're aware of who's in front of you, who's behind you. Under no circumstances should a judge use a vanity plate or have any kind of decal on their vehicle that exhibits to the public that they're in fact a judge. And I mentioned this earlier, the parking place should not have the judge's name, should not have the official title. The judge should never walk outside into a public access space with their robe on. That sort of signals that even if they're surrounded, mind you, by courthouse security or law enforcement, they should never travel outside of those restricted areas with their robe on. That signals to everybody that they're in fact a judge. Residential safety, some of the points I mentioned in terms of hardscaping the courthouse relates also to the judge's residence. So landscaping, lighting, fencing, to the extent possible, surveillance cameras. Consider the capacity, the components that comprise doors and windows, alarm systems, to the extent that you could consider a watchdog, those types of things, proximity sensors, outside lights, inside lights, the types of lights, all those types of things. Make sure that your phone number is obviously not listed, non-published, those types of things, right? And then finally, some of the general vigilance I mentioned, certain events as you're going to and from the courthouse, it can signal kind of sometimes an initiation of an attack. So you have to kind of be very vigilant when it comes to, let's say a pedestrian or a cyclist that falls in front of your vehicle, a person who's stopping your car. This was last year. I was I did a courthouse security seminar in Ghana, and one of the points that was referenced when I was there consulting with, a contingent of judges related to flagmen or workmen that are dressed up as though they are construction workers, and they're stopping judges' vehicles knowing that they're routes as a way of intimidating or trying to attack the judge. So those are the types of things that may not be as prevalent in, let's say, a place like the United States, but you'll have to sort of be aware of such things. Another type of incident would be where they hollowed out an egg, like a chicken egg, and they hollowed it out and they put glue inside the egg. And then as they approached the judge's car, they would throw the egg on the judge's windshield as she was driving. And obviously the judge, thinking it was just some joke, some trick of some sort, the judge put her windshield wiper on. And as she put her windshield wiper on, the faster it went, this glue kind of glossed over the windshield and prevented the judge from seeing the road. So obviously, what as any normal person would do is obviously would pull over. So what they were waiting for the judge, basically a block or 2 blocks maximum, the judge would pull over, she'd get out of her vehicle, and they were able to attack the judge at that point, sort of compelling her to move over. So those are the types of things, emerging threats, things that have come up as of late that you should be aware of. Any kind of disabled vehicle that's on the road, any unusual detour, those types of things. Anything that tries to block or create an accident of sort of distraction for the judge, you have to be aware of. Okay, so those are just some of the final points. I want to thank you all for giving me the time. I'm happy to take any questions that you may have. Thank you.
Thank you so much, Dr. Fazari, for sharing with us such a profound analysis on the importance of the infrastructure as an essential component to ensure secure delivery of justice, as well as for your practical tips being all of them highly effective ways and means to contribute to judicial security and independence. Thank you. We now welcome the presentation by the Honourable Esther Salas, United States District Judge for the District of New Jersey, sitting in Newark, New Jersey. Your Honor, the floor is yours. Thank you.
Bueno, voy a empezar a hablar en español, pero voy a decir a todo el mundo y pedir disculpas. Es mucho tiempo que no hablo en español porque mi mamá se falleció en 2019 y ahora no hablo como debo de hablar con mi familia en español. Pero voy a decir muchísimas gracias para tener este webinar. Es muy importante ahora que nosotros empezamos a hablar de que los peligros que existen en este mundo ahora. Los peligros yo lo sé muy bien porque soy un juez federal y en el 19 de julio de 2020 perdí mi único hijo. Y lo perdí, nosotros estábamos, todo el mundo estaba tratando de vivir bajo una pandemia. Y nosotros estábamos en la casa, era un domingo, estaba celebrando el cumpleaños de mi hijo, que cumplió 20 años. Y ese fue el tiempo que Daniel, mi hijo, su nombre es Daniel, y mi esposo Mark, hablamos bien seriamente si podíamos tener un party para Dani. Pero Dani habló con nosotros y yo dije, mira, hay manera ya que nosotros podemos tratar de asegurar todo el mundo y vamos a tratar de tener un party para Dani. Él invitó a unos amigos del colegio y vinieron bien en la noche y yo no sabía nada. Yo no sabía que un abogado tenía tanto odio que ya estaba deligiándome. He was already looking at my family. He was already stalking my family. We had no idea. Nosotros no teníamos ninguna idea que este hombre ya fue a California semana antes de matar a mi hijo y mató a un abogado que él estaba enfogonado con ese abogado. Y él hizo el mismo cosa que me hizo a mi familia. Él fue a la puerta del abogado, tocó el timbre, él estaba pretending to be a FedEx driver, un FedEx delivery man, que tenía un paquete para el abogado. Y él dijo a la persona que abrió la puerta en San Bernardino, California, semana antes, que esto para el abogado y él tiene que firmarlo. Y cuando el abogado vino al puerta, él cogió el pistola y empezó a darle balazo. Fíjate que entró en el foyer, que se dice donde uno, the greeting area de la casa, y mató al hombre. Quería estar seguro que el hombre estaba matado. Y después se fue. Y cuando él se puso y cogió un tren de California a Nueva Jersey, donde él vino a un hotel menos de un milla de mi casa y empezó a vigilar. He began to stalk my family. Ese viernes, el 17 de julio 2020, él ya estaba enfrente de mi casa. Estaba mirando todo, los niños que estaban viniendo a mi casa, él lo estaba vigilando.
Your Honor, sorry, we just have a problem with the translation. Maybe if we can wait a second so you can start again and it'll take you. Requested all the participants to switch to Spanish as English language, as speaking language, and subtitles to English. I'm sorry to interrupt.
No problem. Let me ask him for a point of clarification. or do we have more participants in English or Spanish? Because I certainly want to do whatever is most convenient for the participants this day.
Thank you. It's quite balanced today.
It is? All right.
It is.
Well, it is? All right. Well, since my English is better than my Spanish, I will do it in English and hope that the translator can keep up with me since I'm a fast talker. As I was saying, the gentleman was talking my house. On Friday, I had no clue. We had no clue. On Saturday, some of the college friends of my son were leaving, this man was on my block the entire time. I had no clue. We, because of the time limit, I don't want to go into all the details, but I can tell you that this man and I locked eyes. I had no idea who he was. I didn't recognize him, although he was a lawyer who had appeared before me a few months earlier. I had no idea what he had in store for my family. And ultimately on Sunday, after all of the friends who had slept over from Friday to Sunday had left, and we had gone to church, my husband and I left our son sleeping upstairs in his bedroom. We came back from church and began to clean up our home from the festivities. And we were in the basement. Daniel and I were in the basement. And I remember my husband coming downstairs, and I remember my son looking at my husband, sort of saying, Mom and I are talking right now. And that was my husband's cue to grab a bottle of water and go right back upstairs. We were again in the basement of our home. And just as my husband went up those stairs, my son, who was, swinging a wiffle ball bat, a baseball bat, and he said to me, Mom, keep talking to me. I love talking to you. And at that exact moment, it was as if, if it was a movie, I always tell people it was as if the director would have screamed, cue the doorbell. And the doorbell rang. My son's face changed from calm and serene to alarmed and concerned. Who's that? He said to me. And before I could tell him, don't worry, Dad's upstairs, he just bolted up those stairs to meet his fate. I stayed downstairs cleaning a few things, and the next thing I hear, what sounded like mini bombs going off, one right after the other. And I screamed, what is happening? And I ran up the stairs, and as I turned the corner, there was my beautiful boy lying perpendicular to the floor, to the door rather, holding his chest. And my husband, who I didn't know it at the time, was shot, seriously, gravely injured, crawling, trying to get the license plate of the man who had just rang our door, who was pretending to be a FedEx driver. From there, I will tell you that the sequence of events, there's not enough time to talk about the pain. There's not enough time to share with you the agony of trying to plan a funeral for my son while trying to be supportive for my husband, who was fighting for his life in the ICU, and begging our political leaders to do something. So there were many things going on in my life at the time in 2020. Again, too difficult in the time frame permitted to really go into the details. But here is what we did, and I say we because certainly I started the journey alone, but I have not ended alone. I am with a lot of people that are interested and care about democracy in the United States of America. And so we started with a state law And the state law is named after my son, Daniel. And it's called Daniel's Law. And the governor of New Jersey, along with the legislators, enacted this law 4.5 months after my son's brutal murder. And the law is a very comprehensive law. It is a law that protects what we call the personally identifiable information of judicial officers, along with prosecutors and law enforcement officers. So New Jersey has enacted a very comprehensive law, and we have created a portal where those that are called covered persons can sign on to the portal, and there's a screening process. And by the way, this law protects active and retired judges, prosecutors, and law enforcement. And what this law does, it's a proactive law. It shields that information that people use to find you. Voter registration, election records, DMV, driving, all of the state agency websites have now, our information cannot be found on those websites. And it has protected the judges in New Jersey, thankfully. So that law, again, very comprehensive. And if you're interested, and if anyone is interested, we have an Office of Information Privacy and a director who would most certainly sit down with any of you to talk to you about how we navigated the portal. The portal is very sophisticated. We got a cyber company to help us manage it, and it has been very effective. That is the New Jersey law. I kept, with my husband, as he was healing, I kept pushing for federal legislation to protect federal judges. And thankfully, on December 23rd, 2022, President Biden signed the Anderl Act, the Daniel Anderl, son's full name, Judicial Protection and Privacy Act, what we call the Act, the Anderl Act. And that act covers federal judges all over the country and U.S. territories. And that act protects our personally identifiable information that is found on any federal website. It also has a mechanism. We now have given control to the director of the administrative office of the courts. And the director, whomever he or she may be at the time, can assist a judge in getting information off websites, private websites, and it is injunctive only. In other words, there is no, there's no civil gain for anyone that is trying to perhaps abuse the law. All it gives is the director the permission to stand in the judge's feet and ask that information be removed from websites. So that is the Anderl Act, and that's the federal law. And I continue to try to speak whenever possible at events like this, as well as traveling the United States, talking to other states about enacting laws that can protect the personally identifiable information, because we have to be proactive. There is no reaction, there's no reactiveness that we can do once something like this has happened. And I do need to stress that Chief Justice Roberts, our Chief Justice of the United States Supreme Court, came out with a report at the end of 2024. And in that report, the Chief Justice talks about a number of things, but he identifies 4 illegitimate attacks that threaten democracy. 4. The first, violence. Violence against judges. Violence against prosecutors. Violence used by those who want to really, as many of the speakers have already talked about, shake the public's trust and confidence in the justice system that is in place wherever you may find yourself. Violence like the murder of my son. I am not the only federal judge that has been attacked, by the way. We have seen federal judges attacked since 1978. Very prominent cases in the United States. But we've seen state judges state judges and local judges are being attacked as well. We have over 30,000 judges who, you know, because there's no centralized way of keeping this data, we don't know how many judges have lost their lives in the line of duty. I can say that we've had prominent cases even after Daniel's murder. We saw Judge Wilkinson, a family court judge, gunned down in front of his home in October of 2023. Judge Romer in Wisconsin was assassinated, let's call it what it is, an assassination by a defendant he had sentenced 15 years earlier, and the judge had already been retired. So if we think the fact that we leave the bench or we leave our positions as prosecutors, that is going to save judges and prosecutors, it's not, because people have vendettas, grudges that they hold on to. And in this case, you know, I do believe that we have to understand that these threats exist and can exist for decades after this Judge Romer found out, unfortunately, when this former defendant went to his house, tied him to a chair, and assassinated the judge, the retired judge. So for me, I think violence is something we all have to be worried about. But here's the second thing that Chief Justice Roberts spoke of: intimidation. Intimidation. And we are seeing a campaign of intimidation like we've never seen before. And Mr. Fazari talked about the pizzas, but I want to be very clear, because people hear pizzas and sometimes they go, what's the big deal? A pizza went to a judge's house. What's the big deal? Here's the big deal. Judges who go home to their sanctuaries and the doorbell rings and it's a pizza they never ordered. What does that say to the judge? It says, we know where you live. Following these numerous pizzas that began to be sent to judges all over the United States, we saw an uptick in the intimidation, in what I'm calling psychological warfare. That uptick was they began to send pizzas to the judge's children. What is that saying to the judge? We know where you live, and we know where your children live. And then on April 6th of this year, the first case that we know of, a judge handling a case with the current administration received a pizza, and the pizza, the person, they ordered it online, and the name associated with the online order was the name of my son, Daniel Anderl. What does that say? It says to the judge, we know where you live. We know where your children live. Do you want to end up like Daniel? Do you want to end up like Judge Salas? And we have had now over 20 pizzas delivered to judges in my dead son's name. We've had 103 pizzas that have been sent to judges all over the United States, to judges at their homes and the homes of their children. 103. This is psychological warfare. This is that intimidation that Chief Justice Roberts warned us all about in 2024. And this is something we have never seen before in the United States. This is why we need to have these webinars. This is why we need to talk about these issues and put them in the perspective that they need to be put into. The third illegitimate attack on the judiciary that threatens our democracy, according to Chief Justice Roberts, is the following: the spreading of disinformation. The spreading of disinformation by political leaders, people in power, people with large social platforms. Why is the spreading of disinformation? Why does it threaten democracy? This is how they do it. They begin to call judges rogue. They begin to call judges out of control. They begin to call judges crazy, leftist, unconstitutional judges, which came out from our administration's spokesperson. Let's be very clear. That quote came from the current administration spokesperson. You threaten articles of impeachment against judges. Judges have never been impeached for doing their jobs in this country. But we know of other countries where judges have been removed entirely because they were doing their jobs against the current administration's wishes. We see that in Nazi Germany. We saw that in Venezuela. We've seen that play out in many, many countries. So the idea of spreading this disinformation and saying it over and over and over again, utilizing media, utilizing social platforms, utilizing interviews, utilizing the government's platforms to call judges rogue, out of control, biased, partisan, without any true basis to do so. Why? Why does that threaten judicial security and independence and ultimately democracy? Because if you say it over and over and you use all of these, the proliferation of this information via the internet and the TV sets, and people begin to believe it, even though we know it's not true. And so that undermines the public's confidence in its justice system when we have political leaders, people in power, people with large social platforms spreading that disinformation. And finally, threatening not to follow lawfully entered orders by the court. That is a threat to democracy. That is when we see, at least in the United States, a crumbling of the foundation that has existed in this country since its founding for well over 200 years. And when people, political leaders, people in power, people with large social platforms even begin to intimate that maybe we shouldn't listen to that judge because we don't like his or her ruling, but we'll listen to this judge because we like his or her ruling, that begins to shake in the foundation of the justice system. People begin to say, why do I have to listen to the judge? Why do we have to follow those orders? Why do we have to follow the law if we don't like it? And there is where we see, again, a threat to the foundation of a justice system that is meant to apply to all evenly. So for me, obviously being cognizant of the time, I don't certainly want to go over the allotted time that I have with you all, but I do think that it's time that we begin to think about, if possible, enacting laws that are proactive in whatever country you might find yourself in, and beginning to gather stakeholders. We have an event this Thursday called Speak Up for Justice. It's the second event that we are holding, and this event is going to be talking about the independence of counsel, which is threatened as well recently in our country. We did one last month talking about the threats to judicial security and independence. But why I think this is important is because we are now rallying together and utilizing the internet like we're utilizing today. We had over 7,000 people join us for that event in April. We hope to have more on May 29th. Speak Up for Justice. If you're interested, Google Speak Up for Justice. You'll see it. And it's at noon Eastern Standard Time. And we're going to have some very prominent speakers, including an active circuit judge of the United States Circuit Court, Judge McEwen. There we will be talking about the threats to the independence of counsel in this country. Speak Up for Justice is important. Why? Because we need to now know if we cannot depend on the government and we cannot entrust that our messaging that our message as neutral, unbiased judges and the system works, we need to take that to obviously the American people too, which is why webinars like this one is so important. Webinars that reach larger audiences, because it is important for us to speak up for justice, to coalesce and to combine our messaging so that we are reaching different segments of our society and reinforcing the justice system, reinforcing the systems that are fairly applied to all. And that is why we need to begin to think about different ways of approaching our messaging. And judges in the United States, as I'm sure judges all over the world, are not very comfortable doing what we're doing right now. What I'm doing right now is an active sitting federal judge speaking about these concerns that I have. Ordinarily, I stay in my lane. Ordinarily, I stay. I want to do my job. That's all I want to do. But sometimes we must do things that feel a little uncomfortable to ensure the comforts of a democratic society. And so I do think that people need to work and communicate with each other their efforts that they're making and taking in order to protect the judiciary. Finally, the little things that we can all do, little things that I have learned over the course of traveling since my son's murder. I've gone and had the benefit of speaking to people like Mr. Fazari, to FBI agents, to marshals all over the country. And they've given me some great tips that I've utilized. And some of the things that I do want to say to both judges and prosecutors joining me here today. Think about mailing or connecting your family and friends to an alias. I use an alias. I never share it with anyone. But when a package comes to my home, or a letter comes, or a card, if it isn't addressed to my alias, I'm not taking it in the house, or I'm confirming that someone sent it. I'm very careful about making sure that it's a friendly package, it's a friendly letter, it's a friendly card. And so if you're my good friend and you're mailing something to my home, then you know my alias. And if you don't, then I'm going to be very careful in how I treat that package. The other thing is limiting your online footprint. All of us love all the social media. Your children love it. They love to say, my family's going on a vacation of a lifetime. You need to have tough conversations with your family members. And you need to tell, especially the younger generation, that not everybody needs to know where you are at all the time. Not everybody needs to know that our family's going to eat at the favorite restaurant, or my dad's favorite restaurant, or my mom's favorite restaurant. If you want to post pictures of your meals, post them after you're home. You don't need to tell those who want to harm you where you're going to be, where you're vacationing. You need to be very protective of your online footprint. And that takes personal responsibility by all of us to begin to change our habits, begin to alter the ease in which we all like to live. So I would say that is something that all of us must begin to do. We must begin to have tough conversations with our loved ones and let them know that they need to change the way they're communicating with their friends. The other thing is utilizing safe words. Safe words. And that is that you tell your little children or your family's children or anyone that if someone calls you and the conversation feels wrong, or somebody tries to go pick up your child at a location, they need to know that if they don't know the safe word, your child should not go with them. Your child should not continue the conversations. And whatever the safe word is with your family, you create the safe words that you know this is legitimate. This is mom and dad telling you you can go with so-and-so. You can talk to so-and-so on the phone. But if that person doesn't know your safe word, communication ceases. You tell or you call the authorities, right? So safe words, the use of safe words. And Mr. Fazari's talked about this, a lot of the stuff I was going to talk about, so I don't want to go over it, but I will tell you that there are many, many online companies now. Companies like Delete Me. Another company that I am very fond of and who is working is Ironwall. But look to see what companies you have available to start trying to remove some of the very information from the internet that can cost you your life, that can cost you the life of your loved ones. Begin to be responsible. Google yourself. See what comes up. You know, the man who killed my son, we found out that he was planning an attack on Justice Sotomayor. He had a file on her. He knew her favorite restaurants. He knew what gym she belonged to. He knew things about her. He had Supreme Court guides, you know, the guides to the Supreme Court to visit. And so he was already collecting information on the justice. So you need to know what's out there that can be utilized by others who want to hurt you. And it's not being paranoid, ladies and gentlemen. It's not paranoia. It's safety. It's common sense. It is being willing to change with the times because the times mandate that. And finally, I want to say that judicial security is not something that should only concern and our personal protection is not something that should just concern us and our family. It really concerns the world, democracy. What is at stake is bigger than sometimes our mind allows us to really conceptualize. And so for me, when we talk about what I can do, what can you do to help promote democracy in your country? What can your family do? What can the people you know, what can they do? These are things you have to start thinking about. And one of the things that I am going to say is that oftentimes we want to believe that we are invulnerable. We want to believe that we can handle this. We want to tough this out. No. This is no time for machismo. This is no time for arrogance or insecurity. This is the time where we ask for help. We encourage everyone to help. We call upon our brothers and sisters to band together to help us, because together we can accomplish much more than we ever imagined. But apart, I'm afraid that the independence, our security, will be lost if we don't unite and band together. And so that is one of the reasons that I sincerely thank the IIJE, the IACA for hosting this important webinar, for talking about these tough subjects, and for inviting us here today to speak up for justice. Thank you.
Thank you so much, Your Honor, for sharing such a deeply personal and moving experience, one that truly transcends words. The way you expressed it with such clarity and strength is truly remarkable. Through your admirable and unique leadership, you were instrumental in the creation of a legal instrument designed to address this grave issue and to protect judges and the judiciary as a whole. Thank you as well for drawing attention to other tragic situations that have impacted the lives of fellow judges and for shedding light on the serious consequences that can arise from seemingly innocuous behaviors. Thank you. Our fourth speaker is the Honourable Santiago Otamendi, Associate Justice of the Supreme Court of the City of Buenos Aires. I've shared with our distinguished audience, particularly those who speak English, if you can switch to Spanish as a speaking language, and then you'll get the translation selecting English for the captions. Justice Otamendi, the floor is yours. Thank you.
Muchas gracias, Luis, allí desde Ushuaia, la ciudad más austral del mundo. Muchas gracias a an International Association for Court Administration, in International Institute for Excellence to Judiciary. Como recién nos comentaba Judge Salas, creo que lo importante es haber traído este tema a la agenda, que ciertamente desde mi percepción como juez hace tantos años, no lo tenía presente como uno de los temas a seguir, a estudiar, a ocuparse. Pero bueno, para ordenar un poco, tengo el privilegio de ser el último que habla hoy aquí, habiendo escuchado a todos quienes me expresaron la palabra, tanto, bueno, Marcelo Varona desde su rol de asociacionismo con los fiscales, Giuseppe Fazari, un experto en seguridad, y bueno, y ahora en último lugar, Judge Salas, toda mi admiración y respeto también su generosidad para contar una historia personal que nos ha sensibilizado a todos. Y también creo que ella nos dejó un par de disparadores, sobre todo el final, cuando nos dice que si no atendemos estos temas, la independencia judicial y la seguridad nuestra como jueces no está asegurada, está en crisis. Así que bueno, yo me voy a limitar a partir de este comentario de Judge Salas y el hilo conductor que ha tenido este importante webinar, justamente para no poner en crisis, sino la necesidad de resignificar el tradicional concepto principio de independencia judicial, ¿no? Donde los jueces eran nominados o seleccionados a través de un sistema que aseguraba, digamos, su capacitación, su independencia, justamente su accionar a través de resolver los casos con apego a la ley, pero parece que hoy día esto es insuficiente. La resignificación o readecuación de este concepto, justamente para construir una política de Estado, tiene que estar acompañado de la seguridad de sus miembros, sobre todo de los jueces y fiscales, a la luz de lo que hemos escuchado hoy día. En nuestra región, como dije al principio, y algo de esto también lo dijo Marcelo y Giuseppe, y lo digo propiamente como juez, uno tiene la sensación de que no está en una situación de inseguridad. Es como se dice aquí en la Argentina, sobra la situación, no tiene estas conversaciones con la familia o amigos, como bien recomendaba recién la Judge Salas, y no es un tema en la agenda judicial como han sido otros temas que últimamente nos han llevado a estudiar desde el court management, access to justice, todo el tema de género, todo el tema de los menores con la problemática de la ley penal. Bueno, temas que obviamente son importantes, pero me parece que poner este tema en agenda es aún más importante porque todos los otros temas dependen de este, ¿no? De la seguridad de los jueces y cómo asegurar para la democracia la independencia judicial. Aquí en la región me da la impresión, y sin ser un experto en la materia, sino observador y teniendo el rol de juez, me parece que la construcción de políticas de seguridad han sido reactivas. Dio cuenta de esto Marcelo con la cantidad de medidas cautelares que pasó revista en la región, pero generalmente la seguridad depende de la evaluación que hace el propio juez o fiscal de su situación frente a un caso complejo y la necesidad de contar con seguridad frente a la concreción de alguna amenaza o una intimidación. Creo que nosotros tenemos que mutar, como decía recién Salas, a una cuestión más proactiva. La redefinición del concepto de independencia judicial nos va a llevar a la construcción de una política de Estado. Esa política de Estado debiera ser, se me ocurre también, como ha dicho también Mark Unger, que es un experto en la materia, a la consolidación de una agencia interdisciplinaria que tal vez dependa del propio Poder Judicial, porque hoy la seguridad generalmente la provee el Poder Ejecutivo con su fuerza de seguridad, la provee de forma no amateur, pero no profesionalizada, alguna policía judicial, en algún ministerio público, Poder Judicial, y tal vez debiera diseñarse una agencia que dependa del Poder Judicial que pueda justamente delinear cuáles son los peligros, los riesgos que hablaban recién, ¿no? La evaluación de riesgos que hablaba Marcelo. Y esto tiene que ver también con la posibilidad de un tejido de cooperación interinstitucional. Si estamos hablando del crimen organizado, el crimen organizado tiene esta posibilidad de trabajar en red, de trabajar con mucha eficiencia, y la respuesta judicial, no solo para castigar al crimen organizado en tiempo, sino también para sobrellevar la amenaza constante que tiene que ver la investigación de estos delitos complejos. O sea, la gravedad de la situación no solo se refiere a la posibilidad de contemplar el peligro que es investigar el crimen organizado, sino también a veces tener la información suficiente para casos menores que pueden tornarse también peligrosos en términos de amenaza externa, como recién refirió Judge Salas. Para esto se necesita también una resiliencia de los poderes del Estado, reaccionar tempranamente, generar las alertas necesarias, el diseño de estas instituciones tal vez nuevas o el rediseño de las instituciones que hay, sensibilizar a los operadores también, ¿no? Esto que decía al principio con una filmina Giuseppe, uno tiene la sensación de seguridad o la falsa sensación de seguridad. Entonces me parece que un primer abordaje debiera ser sensibilizar a los operadores de que este es un tema importante y este tema nos tenemos que ocupar nosotros como miembros del Poder Judicial. Bueno, no mucho más, Luis, para terminar, ya llevamos como 2 horas, así que voy a dar también posibilidad al público. Solo estas reflexiones a partir de haber escuchado a todos, mis respetos, como decía, admiración a Charles Salas, de quien Giuseppe y Aileen nos hablaron mucho en Singapur. También para que el público sepa, el Tribunal Superior de Justicia de la Ciudad Autónoma de Buenos Aires en Singapur, a través de una iniciativa de Luis Palma y Jeffrey Apperson, generó este espacio de diálogo donde el tema fue la seguridad judicial. Y bueno, la continuación de este tema es mantenerlo en agenda, como decía, la importancia de mantenerlo en la agenda, de sensibilizar, de construir políticas públicas, de rediseñar el concepto de independencia judicial. Así que hay mucho por hacer. Yo me alegro también, como decía recién Judge Salas, de mantener este tema presente en la agenda. Hay que trabajarlo. Y se me ocurre en términos de propuestas, tenemos que trabajar en un protocolo general que pueda ser adaptable a cada una de las regiones. Tenemos que fomentar la comunicación y cooperación interinstitucional para prevenir y para reaccionar en tiempo oportuno. Y también, como decía Marcelo, tener un registro para, a través de ese registro, ir identificando patrones, ¿no? Y que nos permite esa información tener un abordaje eficiente y efectivo contra estas amenazas. Así que bueno, muchas gracias, muy buenos días, Luis. Te dejo ahora el floor a vos. Muy agradecido por la invitación.
Thank you so much, Justice Otamendi, for sharing your insights on the conception and development of this public policy in the field of judicial security. Your reflections on these approaches, both historically and current, adopted by judicial systems, as well as your perspective on the future of this vital issue through the development of protocols, offer invaluable guidance for strengthening justice delivery. We'll start now with the questions from the audience and perhaps some from myself. To our distinguished audience, I kindly request you to use the chat box to send them. We have one in advance. It's addressed to Judge Salas. I'm reading now. Does Judge Salas have thoughts on an independent security division for district judges outside the U.S. Marshals who report to the executive branch?
So first, let me say that my relationship with the United States Marshals Service is a very special one. I was under protective detail. My husband and I were under protective detail from the moment of our attack. And that protective detail stayed with us for a significant time frame. And there I met men and women who served the U.S. Marshals all over the country. And I have gotten to know the integrity of these men and women. In fact, I just had a meeting with some division heads from Washington, D.C. just a week ago, a little over a week ago. And so I am of the opinion that the men and women that serve the U.S. Marshals understand their number one objective is to guard and protect judges and to ensure their safety and security. So I want to be very clear that I believe that the objectives of the U.S. Marshals has not changed. And in fact, an incoming director, Director Serralta, promises to uphold the same objectives and commitments as the U.S. Marshals have had for, its inception of the agency. That being said, I also understand that Senator Booker and some other senators are proposing legislation that would enable the U.S. Marshals to be under a different division, not necessarily the second branch of government. And I leave it to our senators, our U.S. House of Representatives to make the determinations that they, as leaders of this country, have been entrusted to enact legislation that they think is appropriate. So I am very mindful that the three articles of the three branches of government have always had tension since the inception of our republic, and that isn't unusual. But what's unusual now is some of the developments that we have seen as of late. So I'm confident that the members of the legislature will make determinations as to whether new changes or laws need to be made to ensure judicial security, and I leave it to them to make those determinations. But I do think that judges have to be mindful that we are in unprecedented times, and therefore I think it is incumbent upon us to consider all plans and determine what plans might be necessary, if at all, ever in the future. So it's all about communication. It's all about collaboration. And really, it is all about all of us remembering that our powers should be entrusted and remain in the article we find ourselves in, whether it be Article 1, Article 2, or Article 3 of our government. So I hope that answers your question, which is, I do believe that everyone has the necessity to consider all avenues, but I leave it to our legislature to make those determinations. But I remain very confident in the men and women that proudly serve the United States Marshal Service, They are dedicated professionals who understand that without the rule of law, we are nothing in this country.
Thank you so much, Your Honor. We have one question, one person, Ms. Jill Hoskins, raised her hand. So if you could kindly send it to us in writing. Oh, here it is. Yes. Ms. Lorna Green, can we access Daniel's law and the report from Chief Justice Roberts online?
Yes, you can access Chief Justice Roberts' year-end 2024 year-end report. I can certainly provide it as well and would be glad to do that to Eileen and anyone else. Lewis, I'd be glad to give you that as well so that your members and the people joining us today can read Chief Justice's profound report. It was very profound, and I think the Chief Justice wrote and really was able to see and continues probably to his words continue to rather to be relevant now more than ever. With respect to the threat numbers, those are ever changing. And in fact, I do have a request as to the threat numbers, but I do know based on my meeting, the numbers that I did say with respect to the psychological warfare numbers, and those are the 103 pizzas or attempted deliveries of those pizzas to judicial officers and their family members, and 20 again in Daniel's name. I will also say that the numbers are such, and I'm looking for my last stat, but the numbers are such that if we continue in this trajectory, we're going to break records. And we don't want to break these records. But there are now threat investigations that have been opened. As of April 25th, 316 threat investigations have been opened. So threat investigations do not get opened unless they find there is a credible threat to the judge or prosecutor. But in this case, this is the judge's numbers. So 316 as of April. That's going to surpass the numbers from the previous year, which was in the 500s. So if we keep up this trajectory, we've got a lot to be concerned about. So I do think the numbers are showing that this is not blustering on the judge's part. This is not hyperbole. This is not, a frantic mother speaking. These are threats. These are numbers. This is real. And with this comes the need for us to do what we need to do to speak up for justice as we're doing today.
So much, Your Honor. We'll make sure to make this information available to the audience. I'll read some comments by Mr. Edis Burkic. It's great to see you again after Kazakhstan in 2019. I would like to propose some of the preventive actions which should take place before these terrible events happen. One is proactive, asking the judges through qualitative and quantitative research what the issues are and pair them with the best international practice in preventing or reducing threats to happen. The other one might look like radical, but it corresponds to what the threat is around. Why to wait for incidents to happen and to learn all these things? Why would not suggest that these things become a part of a training for judges, prosecutors, and law enforcement officers before it occurs? Thank you. Now I'm going to read in Spanish comments from Mr. Juvenal López Rocha from Bolivia. En mi país, lastimosamente, concurren los indicadores señalados por el doctor Marcelo. En los últimos años, el ministerio público, producto de la intromisión política, son objeto de manipulaciones y menoscabo de sus atribuciones en beneficio del partido de gobierno. En este contexto, puedo decir que jueces y fiscales no tienen ninguna seguridad en el ejercicio de sus funciones. Well, these are all the comments from our distinguished audience. are very pleased with all your participation and our outstanding speakers. So I want, in order to close this important webinar, to thank you so much for your excellent, thorough, and engaging presentations that pictured so vividly the importance of public security and its paramount relevance for the delivery of justice. The description of cases, ongoing and newly developments, its benefits and the perspectives were a key part of the whole session. And they show us the challenges that judicial systems are facing to protect judges, prosecutors, and staff members, and this way to contribute to rule of law and social peace. Thank you to the audience for being such a dynamic and committed group, and our apologies for the unexpected technical issues we faced. Soon we'll post on the IGE and IACA websites the links to access to the conference recordings on the IACA YouTube channel, as well as the materials. Please stay tuned. Looking forward to meeting with you soon again. Thank you and goodbye.